Alright, so in this video I'm going to talk about the Unit 2 for the AP exam. This is interactions among the branches of government. This is really looking at the structure, powers, and behavior of the different three main branches of the federal government and how they each affect the policy-making cycle. So if we're looking at the AP kind of exam, CED, list of things we need to know, it looks like a lot, but it can really be broken down to identifying and describing the different structure, powers, and functions of every aspect of the federal government and how they relate to each other. So, right, you're looking at the different houses of Congress, how the structure, powers, and functions of Congress affect the policy-making progress, why members of Congress make the decisions they make, what the role of the president in implementing policy, conflict between the president and Congress, presidential power, presidential communication, looking at the role of judicial review, how the courts make decisions and how the court can affect, and then finally how the bureaucracy can carry out actions passed by Congress, the type of discretionary authority and bureaucratic rulemaking, but also the question of like oversight and the kind of the challenges between the competing branches and competing interests. So for this video, I'm really going to break it down into two parts. First, I'm going to talk about the structure, powers, and relations between the three branches of government. And for this purposes of this video, I'm actually going to put the bureaucracy in with the executive branch where it belongs and not treat it separately. And then I'm going to go into the policy-making process. Okay, so we've got our three branches of government, the legislative, the executive, and the judicial branch. Now, if you've watched the Unit 1 video, you should have a good understanding of their constitutional setup, but I'm going to review that structure, and then I'm going to also talk about their powers and how they relate to each other. So the arrows are going to come at the end. So let's turn to the legislative branch first. So we all know the structure of Congress, right? It's a bicameral legislature with the House and the Senate. In the House, you have 2-year terms versus 6-year terms in the Senate, and representation is proportional in the House, but it is equal in the Senate, with each state getting 2 senators. You also have to be older to be elected to the Senate, but that's less interesting for the purposes of policy making. Now, if we're looking at the structure, we're also looking at the leadership system, right? The leadership system is determined by the majority party, right? Because the Constitution says that the House of Representatives is going to choose its speaker, which usually means that it's the leader of the majority party. There's also in the Senate, the vice president is officially the head of the Senate, and there's a president pro temp when the vice president is not there, but they have less power than the majority leader in the Senate. In the House, there's also a majority leader, but they are basically underneath the Speaker of the House. The minority party is led by their minority leader, and each party, the majority and the minority, have a whip. Now, the goal of the whip is to ensure that the party votes in the way that the party leadership wants them to vote. Now, the Speaker of the House and the Senate Majority Leader are super powerful positions because they ultimately set what the agenda for that House of Congress is going to be. They're the ones that determine, they assign bills to committee. They're the ones that determine what bills get voted on and the rules for voting on those bills. So controlling a lot of times the minority party might have a popular bill that they want to support, but the majority leader or the Speaker of the House might not actually let that bill get through. Congress is also organized into a committee system, and this is super important because the committee system both mediates how the legislative process works. It also becomes a carrot and stick for members for representatives and senators. If you want to get a good committee assignment that's going to help bring back resources to your district, you need to follow the party rules. Most committees are standing committees. These are the couple dozen committees that are the beginning of the legislative process, where bills get referred to when the legislative process begins, and you have this specialization, right? Depending on your area of expertise and interest and your own constituencies, you might be on the Agricultural Committee or the Armed Services Committee or the Banking and Finance Committee, right? These are going to be broken up that way. Most of those committees are also then broken down into subcommittees to further specialize. You have select committees. These are those kind of special focus. They're also known as ad hoc committees to usually investigate some emergency, right? There's a select committee on 9/11. There was a select committee on investigating the election January 6th, right? So you have these special focus committees. Joint committees, there's 4 of them. They involve members of both houses, members of both houses. They're less important. And the last important one is our conference committee. These are created when Both houses pass a bill, but they are not identical. Because remember, before the law can go to Congress or the president to be signed, it has to pass both houses of Congress identically. So you would have a conference committee that's going to reconcile differences in that bill. Now, what are the powers of Congress? Obviously, the most important power is legislation, right? They have all the legislative powers vested in the Congress, and the bills must pass both chambers before going to the president for signing or veto. And if the president does veto it, they can override that veto with a 2/3 majority in both houses. All legislation that deals with revenue has to begin in the House, and this was intended because the House was supposed to be closer to the people, and therefore the power of the purse should be led closer to the people. Congress also has a few other powers, such as the Senate's advice and consent power, when the president appoints nominees to the federal judiciary, to the head executive agencies when they negotiate a treaty. The Senate has the ability to basically approve this. There's also the power of impeachment. The House votes to impeach, right? Those impeachment trials are then tried in the Senate. This is also a specific power that Congress has. If we move to the executive branch, right, executive power is vested in the president and vice president, but the executive branch is more than the president, vice president. We also have the entire cabinet departments, right? Think the Department of State, the Department of Defense, Department of the Interior, Department of Agriculture, right? All of these departments are headed by a secretary of, and then they contain, subparts. So like underneath the Department of Interior, you have the Bureau of Land Management, the Forest Service, the National Park Service. Underneath the Department of Health and Human Services, you have the Food and Drug Administration, the National Institute of Health, right? Those things that are underneath those executive departments. Then you have independent agencies. This is like the Central Intelligence Agency. This is the Security and Exchange Commission. This is the Federal Reserve. These are supposed to be more insulated from politics because these are independent regulatory agencies that are supposed to be staffed by and primarily run as these like apolitical bureaucracies that are seeking to regulate, implement laws and regulate the economies and other aspects. All right, the main power of the executive branch, and by this I mean not only the president and vice president, but also the entire federal bureaucracy, is to enforce the law. All executive power is vested into the president, that power then gets delegated to the various executive agencies that then actually implement the legislation passed by Congress. So one of the ways that this happens is through executive orders in which the president basically directs an executive agency on how they are supposed to implement the law, right? Things like the Clean Power Plan, the Clean Water Rule, but also think of things like more recent executive orders under President Trump that are directing the U.S. Customs and Immigration Services on how they're supposed to implement immigration law. These executive orders have the force of law, but they are not legislation, right? They cannot create new laws. They are basically directing executive agencies on how to implement those laws. Now, a lot of the recent executive orders by President Trump in his second term are really testing that boundary between presidential legislation and executive orders, and that's why there's a lot of challenges in the courts that have argued that a lot of these things cannot be done through executive order. They have to be done through Congress because Congress is the one that passes laws. Now, executive agencies also have the ability to determine how laws are going to be implemented through bureaucratic rulemaking. Let's say Congress passes a law that says we want to have clean water, EPA make it happen. The EPA is going to basically issue rules that determine what counts as clean water. What are the penalties for clean water? What are the specific pollutants that we're looking at? Well, how are we going to measure those specific, what counts as pollution, right? How are we going to enforce this? This bureaucratic rulemaking is actually how these laws get implemented and enforced. We'll talk about that more when we get to the policymaking process. The president is also the commander-in-chief of the armed forces, right? We have civilian control of the military. The military ultimately defers to the commander-in-chief, and the president is the head of state. They represent the United States in foreign affairs. They can negotiate treaties and all sorts of things. They have the power to appoint leaders of the executive branch, right? So you think of your cabinet secretaries, your head of the EPA, your head of the FBI, all those things, but also judges to the federal judiciary, ambassadors to other countries, with the advice and consent of the Senate, of course, and they are required by the Constitution to, from time to time, advise Congress on the State of the Union, right? The State of the Union address is actually a constitutional requirement. It doesn't have to be a televised address, but it is required that, the president update Congress. Now let's look at the judicial branch. Now, if we're looking at the structure of the judicial branch, right, we often think of the Supreme Court of the United States. This is actually the only court that is explicitly mentioned in the Constitution, but it actually then we have a multiple-tiered and dual pathway structure. So, at the bottom level of the federal, we have federal district courts, right? This is where questions of federal law first get settled. Then you can appeal your way up to the circuit courts of appeals, right? And depending on which circuit you are in, your case will be heard by an appellate court, and those appellate courts are going to make a ruling on the basis of law, not fact. Fact-finding only occurs at the district level. And if you still don't like the decision in the Court of Appeals, you can appeal to the Supreme Court if the Supreme Court grants a writ of certiorari. Similarly, at the state level, we have state trial courts, then state courts of appeals, and ultimately state Supreme Courts. These are matters of state law. Now, if there is an appeal you can appeal from the state Supreme Court, especially if you're making an argument about kind of relationship of state to federal law or constitutional questions beyond any particular state. The Supreme Court might hear it, but usually it's going to come from questions of federal law. The Supreme Court is the ultimate court of appeals. It is the kind of final say on what the law on settling any sort of judicial dispute. Now, when we think of the powers of the judicial branch, we're usually thinking about judicial review, right? So we're thinking about this appellate process, right? You sue the federal government for thinking that they're failing to implement some law, or they're implementing some law unfairly, or they violated your constitutional rights, right? And you can kind of appeal all the way up to the Supreme Court. The Supreme Court cannot actually just choose to rule on a law that even if they think, or an action that is unconstitutional, it has to work its way up through the judicial system. They grant a writ of certiorari. That's when 4 of the justices think that there's something worth considering. Only a handful of cases actually make it, less than single-digit percentage of cases are actually heard by the Supreme Court, and then they make a ruling. The kind of process of a judicial ruling, first the courts have to determine that there is in fact standing to sue, right? That there is an actual harm that's being done and that the people are being harmed directly by the action. If there's no actual harm done, if it's just a hypothetical question, the courts won't even rule on the merits. Then, at least at the district courts and the trial court level, there's fact-finding where they are trying to determine what actually happened. They will then interpret the law. What does the law in question mean? What are the relevant statutes? What is the relevant judicial precedent? What does the Constitution say? And then they'll ultimately make a ruling. They might say that a lower court ruling is overturned, right? That the lower court got it wrong. That this executive action is actually inconsistent with the statute passed by Congress, or this action does not, in fact, violate the constitutional rights. They may vacate the ruling, which basically says we're not overturning the ruling, but the ruling is vacated. They might uphold the ruling and say, no, the lower court got this right, you don't get any more appeals. Or they might remand the court with special instructions where they say that the lower court has to rehear the case, but based on a certain issue. Generally, courts are held by this idea of precedent, right? This is the idea behind stare decisis, or let the decision stand, that in the absence of significant legal changes or the fact that a previous court got it wrong, you should follow the precedent set by the higher court, right? So federal district courts are going to follow the precedent set by the courts of appeals and set by the Supreme Court, right? If the Supreme Court wants to overturn a precedent, they need to show either how the laws in question have changed, or why the precedent that was established was incorrect. So if you read the Supreme Court decision in Dobbs versus Jackson's Hole Women's Health, most of the analysis is trying to argue why the legal reasoning in Roe versus Wade was in fact incorrect. Generally, stare decisis is supposed to hold, right? The courts aren't supposed to overturn precedent, but in recent courts there has been much more aggressive overturning of precedent, overturning Chevron, overturning Baca, the affirmative action cases, overturning Roe versus Wade, etc. And that's going to raise questions for this idea of judicial activism versus judicial restraint, right? This question of how much power, how actively should the judicial system be going around overturning precedent or ruling that laws are unconstitutional versus how much more restrained view of the judiciary says that the judicial branch should generally defer to Congress except on extreme cases. So now let's think about how these different branches relate to each other, right? So the red are actions that the legislative can do, the blue are the judicial, and the white are the executive branch. So how can the legislative branch? And this is really kind of going back to James Madison and Federalist 51. So, what can the executive do to check the legislature? Well, they can veto legislation, though that is subject to a veto oversight. They can also have, through bureaucratic rulemaking and executive orders and signing statements, try to temper the ways that the laws get implemented and enforced that are passed by Congress. This is going to create that principal agent problem. It's going to create the need for oversight, which we'll get to in a second. They have a much more direct control over the judicial branch because the president gets to appoint nominees not only to the Supreme Court of the United States, but the entirety of the federal judiciary, right? So the president has a lot of power to shape the kind of nature of the law through the nominees that they appoint. How can Congress affect things? Well, they can limit the power of the presidency because they can override a veto. They also have the advise and consent power that can limit they can kind of they have to get approval for all their nominees to federal agencies and the federal judiciary. And in extreme cases, they can impeach the president or the vice president or for members of the federal executive department. They also have the ability through oversight, right? This is that police patrol versus fire alarm models of oversight. Here, right, they can call in agency heads to hearings. They can subpoena documents. They can subpoena testimony. They are able to oversee that the actions of the executive agencies are actually following what the laws of Congress were intended. Now, when we're looking at the judicial branch, it's a little bit more indirect power. They have some limited power to determine the advice and consent of court judicial nominees. And there's also this idea of court stripping. Court stripping is the idea that you can, through legislation, right, because Article 3 empowers Congress to set legislations about jurisdiction, the size of the court, things like that, that through legislation, if you're mad at a decision that the court has made, you can strip the court of some of its power or its power or jurisdiction. The judicial branch has probably the most obvious checks, right? They can do judicial rule on legislations. They can rule that a law was unconstitutional or a portion of the law was unconstitutional. And they can also rule on executive actions. A lot of what the court does is rule about whether actions taken by the executive agencies or by the president are in fact follow it in line with the statute passed by Congress or in line with the Constitution, right? Remember, but they do not have this kind of active judicial review. They have to wait for things to work up the appellate process. All right, so now we're going to look at the policymaking process, right? The processes by which this bill becomes law and actually gets implemented. So the policymaking process starts in Congress. Someone gets an idea for a bill, they propose the bill, it gets read, it gets referred to a committee for markup. And markup period, right, you're going to have testimony from experts, you're going to hear from lobbyists, from citizens, people are going to make amendments and changes to the bill, then they're going to vote it from the committee to the floor. Most bills die in committee. Way more bills get proposed than ever make it to a floor vote. You can get a bill out of committee through a discharge petition. And then ultimately you're going to have a floor debate, possibility for more amendment process depending on the particular rules that are adopted for that debate. Then you'll have a full floor vote. And if there are differences between the bill that is passed between the House and the Senate, it's going to go to a conference committee. Now, party leadership structures the legislative process, right? The majority party, and therefore the speaker or the majority leader is going to determine where bills get sent to which committees, how they're going to get voted on, what the rules for debates, things like that. And the majority party is also going to have a majority in each of these committees, right? So they're going to determine which bills make it out of committee for a floor vote. Now, the Senate has a special rule called the filibuster, right, which is the idea of unlimited debate. What this means is that on legislation, it is not a kind of budget reconciliation bill, that on legislation, it ultimately means that you need a 60-vote majority in the Senate because the threat of a filibuster in order to pass a cloture motion, which ends debate, requires 60 votes. And therefore, any senator can say, I'm filibustering this bill, moving it from a simple majority vote up to a 60-vote majority. What this means is, especially in a deeply polarized time, that it's harder to get big pieces of legislation passed. So what ends up happening instead is a lot of legislative change gets tied together in omnibus spending bills that people don't want to vote against because they don't want to vote to defund the government or to not spend money or not appropriate money for specific things. The exception to this are what are called the budget reconciliation process. So the processes of budget bills do not require are immune to the filibuster. So a lot of times bills trying to get smuggled in through the budget reconciliation process. Now, how can citizens actually affect this? Well, citizens can affect the composition of the legislative branch through voting. They can they can engage in primary challenges of members of Congress that they don't think are doing a good job. They can contact members of Congress, right? They can write letters, they can call, they can show up in protests at rallies and town halls, right? Or they can, through interest groups, engage in lobbying or campaign contributions to try to influence the members of Congress, right? Now, at the federal level, there isn't really a direct kind of a way that citizens can participate. It's all going to be through these indirect interlinkage institutions. So once the bill gets passed by Congress, it comes to the president's desk where the president gets to sign it or veto. Now, the president, it's kind of a full bill's up or down, right? The courts have ruled that the president does not have the power of a line item veto where they could strike out specific lines from the bill, because that would be to give the president legislative power rather than just executive power. But there is this thing called a pocket veto. Pocket veto is where if the president doesn't sign it and the Congress goes out and Congress goes out of session, that the bill simply dies because the president keeps it in his pocket. This is very rare. Congress usually passes bills well before the time period before it goes out of session, so that the president can't pocket veto it. Now, the president can issue a signing statement while they sign a law, which is a little bit distinct from an executive order, because it's not so much, it's kind of informing. It's a public statement of how they plan on implementing the law. The executive order is actually the explicit directive to the executive agency on how to act or implement. Once the law is signed, right, the bureaucracy then has to make rules on how you're actually going to implement these laws, right? They publish the rule in the Federal Register. It goes to a review and comment period in which interested groups and citizens can actually comment on these rules, in the Federal Register. And then after 60 days, they go into effect. And these are going to change from administration to administration, right? As with elections, the heads of these agencies are going to interpret and implement these laws differently. So this creates what we call principal agent problems. Congress delegates authority to the executive agencies to kind of specify specific criteria for these laws, with the idea that the agencies are experts. Congress aren't going to be experts on water pollution and financial regulations and communications technology and nuclear policy and energy policy, right? And so they delegate these decisions to the experts in the agencies. Now, because they delegate that authority, there's always this risk of agency slack, where especially when the parties change hand, who controls the executive branch, right? A Republican or a Democratic president might seek to interpret and pass rules that are different from what Congress originally intended, hence the need for oversight. Citizens can affect this process too. They can vote for president. They can't vote for agency heads, but the agencies are appointed by the president. They can also, engage in the public comment period. And they can lobby agencies. Remember that idea of iron triangles, right? Interest groups are also lobbying agencies. They say like, hey, you should this is the way that you should write this bill, right? We're going to lobby for Congress to get you more money for your executive agency if you pass this rule rather than this rule. They can also promise sweet jobs when they leave the agencies, pending revolving door regulations. But there is also lobbying for agencies in addition to Congress. Now, let's say that an individual or a state or a corporation or an interest group thinks that the rule that the agency passes is in violation of the kind of Congress's intent, right? So they might sue the EPA or the SEC or some other executive agency and say, look, you're not following the law as Congress has passed it. Now, they can say that, look, this law passed by Congress is actually just unconstitutional. So it starts with a lawsuit, it works its way up to the appellate process, and ultimately the Supreme Court makes the final ruling where they can either uphold or overturn precedent. Now, we've already talked a little bit about judicial activism versus judicial restraint, but the other key idea here is the idea of judicial legitimacy. The idea is that the courts cannot enforce laws themselves, so they rely on this idea of legitimacy, that people believe that the court is a neutral and a legitimate arbiter of the law, that they are not too involved in partisan political processes, and then they make those decisions kind of following the law, and that the people will then follow the law. When people start to feel that the judicial branch is too politicized or is not engaging in good faith actions, then you get the problem of of a constitutional crisis where the people do not trust the judicial branch. People start challenging the judicial branch, refusing to enforce or implement judicial actions, and you kind of have a breakdown. Now remember, how they interpret the law, whether it's a statute or the Constitution, is going to depend on a couple of questions. They might focus on, do we only look at the text of the statute or the Constitution by itself, or do we look at the kind of legislative intent beyond it? And they also might look at the whether or not the meaning of a law or statute is fixed at the time it's written, or if it changes, right? So if their meaning is fixed at the time of written, right, there's some form of originalist. Now, originally, originalists, ironically, looked beyond the text. They looked for this idea of like original intent. But as originalism developed into what we can call originalism 2.0, right, they look at like what was the well-established meaning of the statute when the statute was enacted. If you believe that the meaning changes, but you only look at the text, right, you're a textualist. You think that the text is what fixes the law. Now, even if the text, but the text, kind of like meaning can change a little bit over time, as like circumstances change, right? So that the statute originally says, sex. It wasn't originally intended to cover homosexual activities, and that it was meant to be non-discrimination on the basis of gender. But as things have changed over time, you end up with a bit more of a interpretation of discrimination on the basis of sex that includes discrimination on the basis of sexual orientation, right? Now, if you believe that you're going to look beyond the fixed meaning of the text and beyond the text itself to kind of the broader intent, broader change over time, then you embrace something more like living document, where the idea of the Constitution or the statute sets up a particular framework, and that the job of the judiciary is to interpret that framework in the context of changing circumstances. How can citizens influence the judicial branch? Well, the most obvious way is they can litigate, right? They can sue the government. They can sue other agencies. They can sue each other. That's going to set up conflict that's going to work through the courts. They can also lobby for judicial appointments, right? One of the most famous examples of this is the Federalist Society, which is a conservative legal group that it specifically advises Republican presidents on on who they should nominate to the Supreme Court and to the federal judiciary. Citizens and interest groups, law firms, universities, they can also submit amicus curiae briefs, these friend of the court briefs, to try to influence how the court is going to make decisions. So, right, just to wrap it up, right, we can remember, this unit is very much tied to the unit on the Constitution. If you understand the structure, powers, and functions of the three branches of government and how they relate to each other and how these relations structure the policymaking process, you're going to do just fine in this unit. Next unit will be Unit 3, which is going to be Civil Liberties and Civil Rights.